Good afternoon and welcome to our last webinar of the year, where we will be discussing the importance of beneficiaries and estate planning. We will give everyone a few moments just to join the webinar and we'll commence shortly. So hold tight, we won't be too long. Okay, so thank you all for joining me today. My name is Kelly Barnes and my role at Brighter Super is a Fund Services Manager. We go out and we meet members on a regular basis, and part of our discussion is the importance of understanding the options for nominating a beneficiary in your superannuation and your pension accounts. It is one of our popular topics at our seminars, and we hope by the end of this session you'll have gained a further understanding of beneficiaries and estate planning. I recognise this is a bit of a heavy subject, but hope you stay with me as we talk through what can be a really complex subject. Brighter Super acknowledges the traditional owners of the lands on which we are meeting today and pay our respects to their elders, past, present and emerging. We acknowledge and celebrate the continuation of a living culture that has a unique role in our region. Now, it's important to understand that the information and examples contained in the presentation are general in nature and have been prepared without taking into account your individual objectives, financial situation, or needs. It is important when making decisions about your super options that you obtain the relevant product disclosure statement and target market determination and consider your own personal circumstances. You can access these documents and the Financial Services Guide on the Brighter Super website. Today's presentation, it will run for about 30 minutes. Many of you have submitted some questions already, which we have tried to incorporate into our presentation today. Unfortunately, in the interest of time, we will not have a dedicated question and answer session at the end. However, we will have an opportunity later in this presentation and via the email tomorrow to book in with one of our team, like myself, for a super health check appointment to discuss a range of topics, including your beneficiaries. We will also be running some poll questions throughout today's presentation. When the question pops up on your screen, please just click the answer that is most appropriate to you. Don't worry about taking any notes today. We will send you a recording of this session in the coming days. Now, before we move on to our main topic, I would like to take the opportunity to briefly explain who we are. The merger between LGIA Super and Energy Super, plus the acquisition of SPSL, have enabled us to increase our size and scale, yet we remain committed to investing in the personalised member services that you know and love and enjoy. We manage over 250,000 member accounts with over 30 billion in funds under management. Our My Super option was ranked in the top 5 funds in the peer super ratings for the financial year 2023. Now, let's talk all about beneficiaries and estate planning. So what is estate planning? An estate plan aims to preserve the maximum amount of wealth possible for the intended beneficiaries and flexibility for the individual prior to death. This allows you to be in control of how you would like your estate to be distributed to look after your loved ones. An estate plan helps you protect your family and loved ones, optimize tax upon transfer of assets in a legal and logical manner, and ensure your wishes are followed. Remember that your estate typically consists of everything you own, which are your assets, and everything you owe, which are your liabilities. Superannuation can be one of those assets. It doesn't automatically form part of your estate because super is held in a trust managed by the trustee of your superannuation fund. A death benefit is generally the amount of money in your super account plus any insurance you may have at the time of your death. Whether it's a little or a lot, it could go a long way in supporting your dependents after you're gone. If you've already provided your nomination to Brighter Super, this may expedite the process, which provides peace of mind for where your superannuation death benefit will be paid. Again, it's important to note that a superannuation death benefit does not form part of a member's estate, and it is not necessarily paid as part of your will. If there is no valid binding death nomination, then Brighter Super will determine the distribution of your benefit, subject to the requirements of our trustees' governing rules and legislative requirements. In allocating a superannuation death benefit among the members' dependents, consideration is given to those dependents who might have expected to continue to receive a financial support from the member. Where no beneficiary nomination is listed, the benefit is generally paid to the deceased member's personal legal representative, also called the executor or the administrator of the estate. It can take up to 3 times longer to pay out a death benefit if you do not have a binding death nomination in place. You can instruct Brighter Super who to pay your death benefit to by making either a non-lapsing nomination, a non-binding nomination, I should say, also known as a preferred nomination, or a binding death nomination. Now let's look into these in a bit more detail. So when you first open your account, you are given the option to nominate your beneficiaries. You can review your current nomination by logging into your member online account. There is a tab headed Beneficiaries, which is on the left-hand side, which will provide you with your current nomination. It is important to review this to ensure it is up to date and valid. It is especially important to review if you have had a change in personal circumstances. For example, recently married, divorced, new children, and so on. Your current beneficiary nomination will also be detailed in your annual statement each year. Now let's look at the 2 types of nominations for accumulation, which include defined contribution and defined benefits accounts. Preferred beneficiary nominations. Preferred beneficiary nominations helps guide us when deciding who to pay your benefit to. With a preferred nomination, Brighter Super is not legally required to follow your instructions. This is because the rules set out in the trust deed mean that we must identify all dependents before determining who to pay your benefit to. A binding death nomination. Now, a binding death nomination, this is a legal binding document which binds the trustee to pay your benefit to whoever you have nominated, as long as there is a valid nomination in accordance with superannuation legislation and our trust deed. If you don't have a binding nomination, in the event of your death, we are required by law to determine who best to distribute your money. We do this by following the rules set out in superannuation legislation. For anyone with a more complex family arrangement, the outcome could be very different to what you actually had in mind. Making a binding nomination puts you in control. If you have more than one beneficiary, you can decide what percentage of the benefit you want each of them to receive. For example, your partner could receive 50% and your 2 children could receive 25% each. A binding death nomination gives you certainty over where your money will go. It may be particularly useful, as mentioned, if you have a more complex family situation, such as an ex-partner or children of current and former relationships. A binding death nomination is a legal binding document that obligates Brighter Super to pay your benefit to your nominated beneficiary or beneficiaries, provided the nomination is valid at the time of your death. All nominations could carry risk. If your situation is complex, you should seek estate planning advice. Shortly, we will discuss the difference between a binding death nomination and a binding non-lapsing nomination. And also for members who hold a pension account, we'll cover off reversionary beneficiaries as well. Now, onto our first poll question for today. Have you nominated a beneficiary? Yes or no? Give you a little bit of time to log in for us and let us know. All right, thank you for actively being part of our poll today. Your results are coming through. Now, yeah, it looks like most of us, 82% of us here today, have nominated a beneficiary, which is great. Thank you for doing that. 18% of you haven't, and it is a really important step in your superannuation. So I highly recommend, after receiving today's information, jumping on and having a look at the options and making that beneficiary nomination for yourself. Now, you may have noticed I have mentioned a few times that your nomination must be valid at the time of your death. Let's have a look at who we can nominate as a beneficiary. Now, superannuation legislation dictates who can receive all or part of the superannuation death benefit: the member's dependents and the member's legal personal representative. They're the people who can. A legal personal representative is the executor named in your estate or your will, or the administrator of your estate. If you nominate your legal personal representative to receive your superannuation benefit, then your legal personal representative will distribute the super benefit according to your will. Under superannuation law, a dependent may include a spouse, whether that's a legal spouse, married or de facto, a child, including an adopted child, an ex-nuptial child, a stepchild, and anyone who fits the definition of a child under the Family Law Act of 1975. Any person who had an interdependent relationship with the deceased member, and any person who is financially dependent, whether wholly or partly, on the deceased member. In the instance of a preferred nomination, anyone who was being financially supported just before the member died would be given priority. I think it is fairly clear what the definition is for a spouse or a child, so let's delve a little bit deeper into who is considered a financial dependent and what is the definition of an interdependent relationship. Financial dependence, first of all. A financial dependent is someone who was wholly or partly financially dependent on the member at the time of their death. This may include being reliant on the deceased for the payment of bills, rent, or shared financial commitments such as a mortgage. Documents providing the financial dependency would need to be provided to Brighter Super at the time of the claim. An interdependent relationship. Two people are in an interdependent relationship if they have a close personal relationship and they live together, and one or each of them provides the other with financial support, and one or each of them provides the other with domestic support and personal care. In order to satisfy the criteria for interdependency, all four criteria must be met. So what happens if you don't nominate a beneficiary? Look, if you don't nominate a beneficiary, then we will pay your death benefit according to the rules set out in the fund trust deed and Australian government legislation. This means we look for dependents and determine how best to distribute your benefit. Now, death benefits are tax-free if paid to a tax dependent. This includes a spouse, married or de facto, a child under the age of 18 years, including stepchildren, adopted children, ex-nuptial children, or anyone who fits into the definition of a child under the Family Law Act of 1975. Anyone who was financially dependent on you at the time of your death, and a person who you shared an interdependent relationship with. Now let's go and have a look at how benefits are taxed in more detail on the following slide. In most people's circumstances, there are two taxable components, a tax-free component and a taxable component. The tax-free component are funds contributed after tax as a non-concessional amount. These contributions aren't taxed on the way into super, as they have come from a previously taxed source. An example of this is you've received an inheritance or sale of an asset and put the money into super. The tax component generally holds the greater portion of your super balance. These are the contributions made by your employer, salary sacrifice, and personal deductible contributions plus earnings. Now, these monies have been taxed concessionally at 15% on the way into super. If the benefit is paid to someone who is not considered a dependent, the taxable component of the benefit is taxed at 15% plus the Medicare levy. The untaxed component is taxed at 30% plus the Medicare levy. Generally speaking, it would be unusual for members to have an untaxed component in their superannuation account. This tax refers to funds that usually wouldn't have been taxed based on certain legislation at the time and required to be taxed upon death or upon withdrawal. The taxed and untaxed components are calculated at the time of payment. Generally, everyone has taxable components in their super. The amount in each component will determine how this could be taxed when paying out the death benefit payment to a non-taxable dependent. And let me give you a simple example of this on the next slide. Now, this case study illustrates the potential tax payable for a non-tax dependent. On passing, Jamie has a total balance of $500,000 and wanted to leave this to their adult child. This is made up of the tax component of $400,000, which consists of the contributions their employer made during their life plus earnings. The potential tax payable is 17%, which equals $68,000. This will be deducted and paid to the ATO prior to Jamie's adult child receiving the death benefit. The other $100,000 is tax-free and would pass on in its entirety to the child. The total Jamie's child would receive after tax is $432,000. You can find your individual taxable components in your annual statement or on Member Online through the Benefit Quote tab. If you are concerned about your tax position, there are potential strategies for reducing tax on your death that our financial advice team can discuss with you. I would suggest seeking advice for your own personal circumstance if you feel these strategies may be of benefit to you. Later in the presentation, I will show you how you can actually get in contact with them and book in an appointment. Now, on to our second poll question for today. When did you last check your beneficiary nomination? We've got A, within the last 3 years, B, within the last 3 to 5 years, C, 5 years plus, or D, never. I'll give you a little bit of time to fill that one in for us. All right, coming through now. Great. So it looks like within the last 3 years, 81% of us have gone ahead and checked our beneficiary nomination, which is great. For the rest of us, within the last, 88% within the last 3 to 5 years, 5+ years, another 8%, and never 3%. So for the rest of us, it's definitely worth checking in and seeing who your beneficiary is, making sure that's still relevant and making sure it's the right type of beneficiary for you, whether that be a binding beneficiary or a preferred beneficiary. And as I said, you can check that out in your Member Online account or on your annual statement. All right. Now, as I just mentioned, there are different types of death benefit nominations. Let's look into each of these in a little bit more detail now. Now, the first one to discuss is the preferred or non-binding nomination. This can be completed via Member Online, and there's no time period or expiry on this one. Now, this nomination can be updated at any time through the Member Online portal. It is important to remember, however, that this is an expression of your wishes, but it is not binding, and Brighter Super is legally required to identify all of your dependents and pay your benefit according to the rules set out in the LGIA Super Trust Deed. Okay, so not legally binding. The next way to complete a binding nomination, this can either be lapsing or non-lapsing. Okay, so we've got a binding lapsing nomination first. This one will be valid for 3 years from the date the form is signed. You will need to complete a new nomination every 3 years or earlier if your situation changes. We will advise you when it is due to expire, but you will need to ensure you complete a new nomination on your nomination, or your nomination will lapse. Okay, so if you don't update that every 3 years, it will lapse and fall back to a preferred nomination. However, we do have a non-lapsing option as well. So the non-lapsing option, as the name suggests, it will be valid from the date the form is signed and remain in place until revoked or amended. The nomination does not expire, however, its validity will be assessed at the time of your death. You can replace or cancel your nomination for either the lapsing or non-lapsing at any time. Your form must be witnessed by 2 people over the age of 18 who are not nominated as beneficiaries. Everyone must sign and date the form on the same day. The form can have no errors. Do not cross out and initial any errors, as the nomination form will be rejected if you do so. If you make a mistake, print out a new form and start again. You can post or email the form to us for actioning. Another important note is if you are nominating more than one beneficiary, then the total of all shares allocated to each beneficiary must equal 100%. Remember to update your nomination whenever your situation changes. The final option is a reversionary nomination. Now, this option only applies to members who have a pension account. A reversionary beneficiary nomination allows you to have your pension continue to be paid as a pension to your beneficiary, generally your spouse, upon your death. You are also able to nominate a preferred or binding death nomination instead of a reversionary nomination on your pension account if you wish. Your nomination is legally binding and does not lapse. We recommend reviewing your reversionary nomination regularly to ensure that it is still appropriate for your situation. Who you can nominate as a reversionary beneficiary is outlined on the form. The beneficiary is generally your spouse. There is an option for children, however, at this age, financial or disability dependent, please refer to the form for all the relevant options. You can also refer to the Brighter Super Pension Product Disclosure Statement for further guidance. There may be social security or tax implications for your potential beneficiaries when making a reversionary nomination. Our financial advisors may be able to help you decide how best to deal with your superannuation. Apart from seeking financial advice, we would also suggest you seek independent estate planning advice. Learn Chow from YHC Lawyers regularly presents at our face-to-face seminars where she speaks about the importance of wills and estate planning and enduring power of attorneys. YHC Lawyers details are on our screen, and if you are interested in speaking about your situation, you can scan the QR code for further contact information. As a boutique fund, you'll also have the option to book in a 30-minute super health check at no additional cost. The super health check covers a variety of areas and importantly reviews your beneficiary nomination. If you'd like to book now, there is a QR code on screen. You'll also receive a link to book a super health check in the coming days alongside today's webinar recording. We also offer a range of personal advice options suited to your individual members' needs. Now, if you're looking for specific information about making contributions or investment strategies, our intra-fund advice team can help. Book in an over-the-phone meeting with a financial advisor at no additional cost for personal financial advice. We also offer both a scaled and comprehensive personal advice service. This service takes a complete view of your financial situation to tailor advice to suit your individual needs. It is a face-to-face meeting with one of our advice team in Brisbane and various regions over Queensland. Appointments may be arranged via digital channels as well, like Zoom, Teams, etc. The cost will depend on the complexity of the advice, and this cost may be deducted from your Brighter Super accumulation account. Two of the most common questions members ask us as they approach retirement are, how much super do I need to retire? And do I have enough super? A retirement health check with one of our financial advisors will help you answer these questions. It's never too early to start planning for retirement, so talk to us and to find out how we can help in any way. And webinars like this one, they're a great way to get specific information on a variety of different topics. This is not the only webinar we have or the only one that we will be holding. Go to our website or scan the QR code on the screen to find out what is coming up. Keep an eye on this page as we update it regularly, and in the coming weeks, we'll be adding the 2024 webinars onto this webpage. If you register for any webinars, regardless if you attended or not, you will receive a copy of the recording the next day of the webinar. I have covered a lot of ground today. You can also visit the resources tab, then forms and info sheets on our website for more information on the different forms we have discussed today and handy information sheets as well. So thank you again for taking some time and coming along today to attend our webinar. One last question before we bring things to a close. Overall, how satisfied were you with today's webinar? Very satisfied, satisfied, dissatisfied, or neither satisfied nor dissatisfied. Thank you so much for attending today's webinar, which is actually our last one for 2023. So a very special group with us today. We hope you join us in 2024 for our next round of webinars. Thank you so much, everyone. Enjoy the rest of your day. Bye-bye.